A federal judge just issued the most sweeping asset freeze order in American presidential history. United States District Court Judge Elena Hartwell of the Southern District of New York signed an emergency injunction at 6:47 this morning, freezing all financial accounts, real estate holdings, and corporate entities connected to Donald Trump, his family members, and the Trump Organization, pending a federal asset forfeiture proceeding that Justice Department officials are calling the largest in the department's 235-year history. And this isn't a temporary hold while paperwork gets sorted out. This is a court-ordered lockdown backed by sealed grand jury indictments, forensic financial evidence spanning 11 years, and testimony from 47 cooperating witnesses whose identities remain protected under federal law. When a sitting federal judge signs an asset freeze targeting a former president's entire financial empire, including his personal residence, at dawn on a Tuesday morning, you know the legal foundation beneath this presidency just collapsed entirely. Hit that subscribe button right now because you won't want to miss any of the videos I release. So, what triggered this unprecedented judicial action? According to multiple sources with direct knowledge of the proceedings, federal prosecutors filed sealed emergency motions with Judge Hartwell's court on the evening of March 3rd, presenting evidence that Trump Organization executives had been moving assets across international borders at an accelerating rate over the previous 72 hours, with wire transfers totaling $340 million routed through shell companies in the Cayman Islands, the United Arab Emirates, and Cyprus. Sources say the evidence includes forensic banking records, intercepted wire transfer documentation, and sworn testimony from 3 former Trump Organization chief financial officers who entered cooperation agreements with the Justice Department between January and February of this year. This isn't just another civil lawsuit or a partisan legal maneuver. Constitutional scholars are calling this the most consequential judicial action against a former president since the Supreme Court's unanimous ruling in United States versus Nixon in 1974. And believe me, when a federal judge signs an emergency asset freeze at 6:47 in the morning before financial markets open, the legal strategy is not about making a procedural point. It is about preventing the movement of evidence before it disappears entirely. Here's the full picture of what's been unfolding. Tensions have been building since November of last year when the Justice Department's Financial Crimes Enforcement Network opened a formal investigation into what it described in internal documents as a systematic pattern of potential asset concealment connected to multiple ongoing federal prosecutions. But everything escalated to a breaking point on February 28th when a sealed federal grand jury returned indictments on 7 counts of bank fraud, 3 counts of obstruction of justice, and 4 counts of money laundering against Trump Organization entities. Indictments that remained sealed until this morning's asset freeze made their existence impossible to conceal. The emergency injunction, executed by United States Marshal Service agents beginning at 7:15 this morning, covered 43 distinct properties including Mar-a-Lago in Palm Beach, Trump Tower in New York, the Trump International Hotel in Washington, and 26 additional commercial and residential properties across 9 states. According to federal officials who spoke to reporters on background, marshals arrived at Mar-a-Lago's main entrance at precisely 7:23 this morning, presented the signed court order to on-site security personnel, and secured the property's financial offices, document rooms, and server infrastructure within 40 minutes. Security cameras recorded the moment. Staff were escorted from financial administration areas. The property remains accessible to residents and guests, but is now under active federal oversight. According to sources familiar with the court filings, the evidence presented to Judge Hartwell detailed a pattern of financial conduct spanning 11 years in which Trump Organization entities allegedly transferred assets to foreign-controlled accounts in anticipation of legal proceedings, a practice federal prosecutors characterize in their filings as systematic obstruction of potential asset forfeiture. This wasn't about political disagreements over tax strategy or aggressive but legal financial structuring. This was about federal prosecutors presenting a court with evidence of what they allege was coordinated, deliberate movement of hundreds of millions of dollars specifically to frustrate federal law enforcement. Smash that like button if this is making sense so far. Here's where it really gets serious. Within 3 hours of the asset freeze order becoming public at 9 o'clock this morning, Senate Banking Committee Chair Sherrod Brown called an emergency session of what he described as an oversight task force in the committee's secure conference room on Capitol Hill. According to committee staff who were present in the corridor, 22 senators attended that meeting, including Senate Judiciary Chair Dick Durbin, Senate Finance Committee Ranking Member Mike Crapo, Senator Elizabeth Warren, Senator John Tester, Senator Mark Kelly, and, in a development that stunned longtime Capitol observers, 4 Republican senators who requested their attendance remain off the official record until the meeting concluded. The session lasted 2 hours and 40 minutes, and what happened inside, according to multiple senators who spoke on condition of anonymity to reporters immediately afterward, was described as the most urgent and legally consequential gathering of Senate leadership since the January 6th Select Committee convened its first classified briefing in 2021. Senator Brown began the meeting by stating plainly, according to sources who recounted his remarks, "We have before us a federal court order that treats a former president's financial empire the way we treat organized crime assets. The Justice Department did not take this step lightly. Neither should we. The question before this committee is whether Congress was deliberately misled about the financial structure of entities at the center of these proceedings, and if we were, what our constitutional obligation is now. History is watching what we do in the next 72 hours." The room fell silent. Senator Mike Crapo, Republican of Idaho, who has consistently opposed what he characterized as politically motivated investigations of Trump, reportedly stood and said, his voice measured but his expression visibly troubled according to witnesses, "I need to be honest with my colleagues about what I've seen in the sealed briefing materials. I came into this room prepared to characterize this as prosecutorial overreach. The documentation I reviewed last night doesn't support that characterization. There are financial records here that I cannot explain away, and I've spent 30 years working on banking legislation. When I cannot explain the records, we have a serious problem." According to senators present, Crapo's statement fundamentally changed the dynamic of the room. Senator Elizabeth Warren, who sits on the Banking Committee and had reviewed the same sealed briefing materials, reportedly added, "The forensic trail is not ambiguous. There are 11 years of documented transfers. There are 47 cooperating witnesses. There are foreign bank records obtained through mutual legal assistance treaties with 6 governments. If the evidence in those sealed filings is what it appears to be, we are not looking at aggressive tax planning. We are looking at systematic financial fraud on a scale this country has not seen prosecuted at this level before. Drop a comment right now if you saw this coming. I read every single one. Now things get absolutely explosive." By noon on the same day, Senate Banking Committee leadership had drafted and circulated a formal request for a classified briefing from the Justice Department's asset forfeiture and money laundering section, an extraordinary step given that Congress rarely inserts itself into active federal prosecutorial proceedings. According to Senator Brown, who explained the decision in a brief press statement outside the committee room, "The American people have a constitutional right to understand whether their institutions are functioning properly. When a federal court freezes assets of this scale connected to a former president, Congress has an oversight obligation. We are meeting that obligation." The formal committee request, submitted to the Justice Department at 12:47 this afternoon, identifies specific concerns in 3 areas. First, the request asks for confirmation of whether any current or former executive branch officials provided advance notice to Trump Organization entities about the timing of the asset freeze order. Second, it asks for documentation of any communications between the White House and the Justice Department regarding the prosecutorial timeline. Third, it asks for a classified accounting of the specific foreign jurisdictions involved in the alleged asset transfers, and whether those jurisdictions include nations currently subject to active diplomatic or intelligence concerns. But the truly devastating element of what emerged this afternoon is not what the senators requested. It is what was already included in the publicly available portions of the court order. One paragraph of Judge Hartwell's injunction states, "On September 14, 2024, wire transfer documentation obtained pursuant to a mutual legal assistance treaty request to the government of Cyprus confirms that $47.3 million was transferred from Trump Organization International LLC to an account held by an entity identified in sealed proceedings as Respondent Entity 7, within 96 hours of the subject receiving notification of a prospective subpoena from federal prosecutors." Another section of the order details, between January 8, 2025 and February 22, 2025, Forensic analysis of financial records obtained pursuant to court order identifies 41 separate transfers totaling $218.6 million routed through entities and jurisdictions with limited financial disclosure requirements, representing a 340% acceleration in transfer volume compared to the same period in the prior year. This order sent shockwaves through the financial and legal communities simultaneously. When a federal judge cites specific dollar amounts, specific dates, and specific foreign jurisdictions in a publicly filed court order, and when that order is executed by United States Marshals before financial markets open, the legal strategy is not preliminary, it is prosecutorial endgame. This is not the first time Trump has faced legal proceedings of significant scale. The first impeachment in 2019 involved allegations of improper pressure on a foreign government. Senate Republicans dismissed the charges as a policy dispute dressed as a constitutional crisis. The party held together. Only one Republican senator voted to convict. The proceedings ended in acquittal and the political coalition held. Then came the second impeachment following January 6, 2021. 7 Republican senators voted to convict, the most bipartisan conviction vote in impeachment history. Legal scholars called it extraordinary, but it still fell 14 votes short of the 2/3 threshold, and most Republicans argued the constitutional standard had not been met. Both times, the political structure surrounding Trump proved durable enough to survive. Subscribe immediately if you haven't yet. This content doesn't exist anywhere else. Now it's completely different. This proceeding is not driven by congressional votes or political coalitions. It is driven by a federal court order signed by an Article III judge with lifetime tenure, backed by sealed grand jury indictments, and executed by federal law enforcement agents. The allegations involve forensic financial documentation obtained through international treaty mechanisms, not disputed interpretations of phone calls. The charges involve alleged systematic asset concealment, not policy disagreements, and 47 cooperating witnesses have already provided sworn testimony, with the Justice Department indicating in public filings that additional cooperation agreements are pending. The pattern is unmistakable. Previous proceedings against Trump were ultimately political in nature, subject to the mechanics of partisan loyalty. A federal asset freeze executed by United States Marshals is not political. It is structural. It operates on an entirely different legal plane. So what exactly triggered this mass judicial action? According to sources with direct knowledge of the proceedings, 3 specific pieces of evidence proved dispositive in Judge Hartwell's decision to sign the emergency order. First, forensic banking records documenting the accelerating asset transfer pattern. The Justice Department's Financial Crimes Enforcement Network presented Judge Hartwell with a forensic analysis covering 11 years of Trump Organization financial transactions, identifying what prosecutors describe in their filings as a clear and statistically anomalous acceleration in international transfers, beginning the day after Trump's November 2024 legal team received notification of the prospective indictments. According to Michael Zeldin, former federal prosecutor and deputy independent counsel under Robert Mueller, who reviewed the publicly available portions of the court order, what the judge is describing in this order is a classic flight pattern. When you see a 340% acceleration in international transfers to low-disclosure jurisdictions within days of a subject receiving legal notification, that is the documented signature of asset concealment. That is exactly the pattern federal courts are designed to interrupt. Second, the testimony of 47 cooperating witnesses spanning 3 tiers of the Trump Organization's financial structure. The Justice Department's filing identifies cooperating witnesses including former chief financial officers, former outside accounting firm partners, former legal counsel, and former international banking intermediaries who facilitated transfers across multiple jurisdictions. According to Senator Warren, who has reviewed classified portions of the briefing materials, when you have 47 cooperating witnesses across 3 organizational tiers, you do not have people guessing at what happened. You have people who were inside the rooms where decisions were made, who documented what they saw, and who are now testifying under oath with criminal penalties for false statements. That is not a circumstantial case. Here's the absolute kicker. The third piece of evidence involves contemporaneous internal communications, text messages, encrypted application records, and internal memoranda, obtained through court-authorized search warrants executed on devices surrendered by cooperating witnesses, which prosecutors allege show Trump Organization senior leadership explicitly discussing the legal proceedings and explicitly directing the acceleration of international transfers in response. One document, a portion of which was declassified and included in the public exhibit to the court order, describes an internal communication from February 14, 2025, in which a senior executive allegedly wrote to a financial intermediary, "Everything moves before the end of the month. The lawyers say we have 60 days, but I'm not waiting 60 days. Start with the Cyprus accounts and work down the list. Don't put anything else in writing. Don't go anywhere. The most explosive part is coming next. And here's what should alarm everyone, regardless of political affiliation." This isn't just about Donald Trump or this specific alleged financial conduct. If a former president can allegedly move hundreds of millions of dollars across international borders in apparent anticipation of federal prosecution, and if that conduct goes without the swift judicial intervention of the kind we saw this morning, then the message sent to every future president is that the window between receiving legal notification and the arrival of federal enforcement is a window of opportunity, not a moment of accountability. Once that precedent is established, the deterrent effect of federal asset forfeiture law as applied to the most powerful individuals in the country is functionally eliminated. Every future president, every future senior official will understand that wealth and legal resources can create enough friction in the system to move assets beyond the reach of American courts before accountability arrives. The implications for the rule of law are not theoretical. They are structural and immediate. This puts Trump in an absolutely impossible legal and financial position. On one side, he faces active federal court oversight of his entire financial empire, with marshals physically present at his properties and court-appointed financial monitors now reviewing every transaction above $100,000 in real time. That alone represents a catastrophic constriction of the financial flexibility that has defined his business model for 5 decades. On the other side, he confronts the reality that 47 cooperating witnesses have already provided sworn testimony that federal prosecutors found credible enough to persuade a federal judge to sign an emergency asset freeze order. And here's the impossible bind. If Trump claims the asset transfers were routine business activity unrelated to legal proceedings, he directly contradicts the forensic pattern documented in the court order showing a 340% acceleration in transfer volume beginning the day after his legal team received notification of pending indictments. If he admits the transfers occurred but claims they were directed by lawyers as legitimate legal financial planning, he implicates his own legal team in the conduct prosecutors are characterizing as obstruction, potentially destroying the attorney-client privilege protections he is simultaneously relying on for his defense. If he argues the federal court lacked jurisdiction or the evidence was improperly obtained, he faces the reality that the order has already been executed, the assets are already frozen, and 47 cooperating witnesses have already provided testimony that exists independent of any evidentiary challenge. There is no defense strategy that addresses all 3 pieces of evidence simultaneously. Constitutional scholars and former federal officials are now describing this morning's events as the most consequential legal action against a former American president in the history of the Republic. Professor Erwin Chemerinsky, dean of UC Berkeley School of Law and one of the country's foremost constitutional scholars, stated in a written analysis released this afternoon, "The scope of this asset freeze is without precedent in American legal history as applied to a former president. Federal courts have the authority to take this action. The question the country will now confront is whether the rule of law applies uniformly to all Americans regardless of political status. This morning's court order is a direct test of that principle." Former United States Attorney for the Southern District of New York, Preet Bharara, told CNN, "This order does not get signed unless the Justice Department presented Judge Hartwell with evidence she found compelling under a very high legal standard. Federal judges in this district do not sign emergency asset freeze orders at 6:47 in the morning to make a political statement. They sign them because the evidentiary record supports it and because the risk of asset dissipation is real and immediate." Even former Trump administration Treasury Secretary Steven Mnuchin, in a statement released through his spokesperson this afternoon, acknowledged, "I cannot speak to the specific evidence in these proceedings. What I can say is that asset freeze orders of this scope and this speed are not issued casually. The legal standard for emergency injunctive relief in federal court is substantial, and the court clearly found it met." Do me a favor and slam that like button because it genuinely helps this video reach more people. So, let's break down what this means. First, immediate financial paralysis across the entire Trump organization structure. All 43 properties under the freeze order are now subject to court-appointed financial oversight. No asset sales, no international transfers above court-monitored thresholds, No new financing arrangements without judicial approval. The Trump Organization employed approximately 22,000 people across its global portfolio. Every one of those employment relationships now exists under the shadow of a federal asset freeze that has no established timeline for resolution. The practical disruption to daily business operations is immediate and total. Second, the cascading effect on ongoing and pending legal proceedings in multiple jurisdictions. The asset freeze order will be immediately cited by plaintiffs' attorneys in civil proceedings across New York, Florida, Georgia, and the District of Columbia. Attorneys who previously struggled to enforce civil judgments against Trump Organization entities now have a federal court order effectively doing the preliminary work of asset identification for them. Foreign governments party to the Mutual Legal Assistance Treaty cited in the court order may face their own legal obligations to assist in asset recovery. The international legal tentacles of this morning's order extend far beyond American borders. Finally, the institutional precedent this establishes for future presidents and future federal enforcement. If the Justice Department successfully executes a full asset forfeiture proceeding following this morning's freeze, through the full adversarial process with all of Trump's legal defenses engaged, it establishes definitively that no individual's political status or financial resources place them beyond the reach of federal asset forfeiture law. That precedent will define the relationship between presidential power and federal law enforcement for a generation. Drop a comment below with your thoughts. I'm genuinely curious to see your perspective. But beyond immediate legal and financial disruption, this represents a test of whether the American constitutional system can enforce accountability uniformly when the subject of enforcement is the most politically polarizing figure in the country's recent history. The founders built federal courts with lifetime tenure and constitutional independence precisely so that judges could make decisions of exactly this kind, decisions that will generate enormous political controversy without fearing for their positions. Judge Hartwell signed this order knowing its implications. The system placed that authority in her hands for exactly this kind of moment. If the system functions as designed, the asset freeze holds, the prosecutorial proceedings advance through full due process, and the rule of law is demonstrated to apply without regard to political identity. If the system is overwhelmed, if political pressure causes judicial hesitation, if cooperating witnesses face intimidation, if the international asset recovery efforts stall in foreign courts, then the gap between the rule of law as a principle and the rule of law as a practical reality will have been exposed in the most consequential possible terms. This scenario is causing absolute pandemonium within Washington's legal and political communities simultaneously. Reports indicate that the Justice Department's asset forfeiture and money laundering section has been in continuous operational session since 4 o'clock this morning, managing the execution of the court order across 9 states and coordinating with foreign government counterparts in 6 jurisdictions. Congressional leadership faces an impossible calculation. Republican leaders must decide whether to publicly oppose a federal court order executed by career law enforcement agents under a sealed grand jury indictment, a position that places them in direct rhetorical conflict with the rule of law, or remain silent and allow the proceedings to advance without political resistance. Democratic leadership must manage the optics of appearing to celebrate a prosecutorial action while simultaneously insisting the proceedings be allowed to advance through proper legal channels without political interference. Meanwhile, the legal team surrounding Trump is in documented crisis. 3 senior attorneys withdrew from representation within 2 hours of the asset freeze order becoming public, citing conflicts that they declined to specify in their court filings. Early statements from Trump's remaining counsel characterized the order as a weaponization of the judiciary against a political opponent and demanded immediate appellate review. But legal analysts noted that the statements addressed the political characterization of the proceedings rather than the specific evidentiary basis for the court's decision. And polling conducted by 3 separate firms in the hours immediately following this morning's announcement shows that 71% of Americans believe the court proceedings should be allowed to advance without political interference, including 44% of self-identified Republicans. Trump addressed his supporters via social media at 2:15 this afternoon. He denied all allegations, characterized the asset freeze as a political attack by what he described as a corrupt and weaponized judicial system, called for the immediate removal of Judge Hartwell, and claimed the cooperating witnesses were lying under prosecutorial pressure. But legal observers immediately noted that Trump's statement did not address the specific forensic financial documentation cited in the court order, the specific dates and dollar amounts identified in the public exhibits, or the specific pattern of transfer acceleration that formed the evidentiary basis for the emergency injunction. Stay with me because what comes next will completely change your understanding of where this leads. Here's what makes Trump's position so precarious and his response so legally dangerous. By publicly attacking Judge Hartwell and calling for her removal in the same hours that her order is being actively enforced, Trump is creating a documented record of what prosecutors can characterize as ongoing attempts to interfere with judicial proceedings, conduct that falls squarely within the obstruction counts already contained in the sealed indictments. Every public statement attacking the judge, every call to pressure cooperating witnesses, every demand for political intervention in an active federal prosecution creates additional documented conduct that prosecutors can present as evidence of consciousness of guilt and continued obstruction. Political analysts immediately recognize the strategic disaster. Andrew Weissman, former FBI general counsel and senior prosecutor on the Mueller investigation, stated on MSNBC, "Every attack on the judge, every characterization of cooperating witnesses as liars, every demand for political interference, these are being preserved as exhibits. This is not a political fight where aggressive rhetoric helps. This is a federal courtroom where aggressive rhetoric becomes evidence." Former Republican National Committee Chairman Michael Steele, speaking on CNN this afternoon, observed, "The strategic error here is treating a federal asset forfeiture proceeding like a political campaign. You cannot attack your way out of a court order. You cannot intimidate a federal judge the way you can intimidate a primary opponent. The rules of the arena are completely different, and the response we are seeing today does not appear to account for that difference. This goes far beyond one proceeding or one former president. It is about whether the United States maintains a legal system in which the tools of federal asset forfeiture, tools that have been used against organized crime, drug trafficking organizations, and financial fraud at every level of American society, apply with equal force when the subject is a person with enormous political resources and a devoted political following. If they do not, then the rule of law in this country is not a principle. It is a practice that applies selectively based on political identity. That is not the country the founders designed. That is not the country the federal judiciary was built to produce. If this blows your mind, hit that like button right now. Here's the current situation. A federal judge has signed and executed an emergency asset freeze order covering 43 Trump Organization properties and all associated financial accounts. 47 cooperating witnesses have provided sworn testimony underpinning sealed grand jury indictments. United States Marshals are physically present at Mar-a-Lago and 22 other properties as of this moment. And the full adversarial legal proceedings that will determine the ultimate disposition of those assets have not yet formally begun. This isn't political theater or a partisan legal maneuver. This is the most consequential application of federal asset forfeiture law to an individual of presidential stature in American history. When a federal judge signs an emergency order at 6:47 in the morning, when 47 cooperating witnesses provide testimony compelling enough to persuade an Article III judge to freeze a former president's entire financial empire, when United States Marshals physically secure the property where a former president resides, the system is being tested in ways it has never been tested before. Keep an extremely close eye on this story because the adversarial proceedings that follow this morning's asset freeze will determine not just the financial future of the Trump Organization, but the practical meaning of federal law enforcement accountability in this country for the next generation. The appellate review of Judge Hartwell's order is expected to begin within 72 hours, with Trump's legal team filing emergency motions seeking a stay of the freeze pending full briefing. Federal prosecutors will present the sealed evidence in adversarial proceedings that could last months. The 47 cooperating witnesses will testify. The forensic financial documentation spanning 11 years will be tested through the full adversarial process. And at the conclusion of proceedings that could represent the most consequential federal prosecution since the Watergate era, the courts will render a judgment on whether the conduct described in those sealed filings meets the legal standard for asset forfeiture. Trump's legal survival depends on dismantling the evidentiary foundation that persuaded Judge Hartwell this morning, a foundation that includes forensic banking records, international treaty-obtained documentation, and 47 sworn witnesses. But his strategy of publicly attacking the judge and characterizing all cooperating witnesses as liars appears to be reinforcing rather than undermining the prosecutorial narrative of ongoing obstruction. Before we go any further, smash that subscribe button so you never miss content like this, because this constitutional crisis is unfolding in real time and represents the most serious legal test of presidential accountability in modern American history. Here's where things stand right now. A federal court has frozen the entire financial empire of a former president of the United States. The evidence underpinning that order includes forensic banking records, international treaty documentation, and 47 cooperating witnesses across 3 organizational tiers. Trump's response has been to attack the judge and deny the evidence, a strategy that legal experts say creates additional prosecutorial exhibits rather than dismantling the existing ones. The proceedings that will determine whether these assets are permanently forfeited to the federal government have not yet formally begun. This isn't a procedural skirmish or a temporary legal setback. This is the federal government's most powerful financial enforcement tool, applied at the highest level it has ever been applied in this country's history. The stakes have never been higher for the principle that no American stands above the law. The evidence has never been more forensically documented, spanning 11 years and 47 cooperating witnesses, and the constitutional moment has never been more immediate or more consequential. Pause for a second and hit that like button if you're finding value in this coverage.